between the three organs of government. So that brings us to the question of why do we need ouster clauses at all? And there are many reasons, and I've highlighted three. The first is the doctrine of separation of powers, which requires that an organ of government cannot control or interfere another organ of government. So based on this doctrine of separation of powers, the constitutional ouster clause prevents interference by the judiciary on administrative action or legislative action. And secondly, the reducing litigation. So litigation, as you know, in Sri Lanka, litigation is very time consuming, and also the attendant costs of litigation. So to reduce that, to reduce the amount of litigation that comes up, these ouster clauses play a part. And also to allow for efficient government, because if a government authority or an administrative authority is constantly plagued by many injunctions or judicial or litigation, then it cannot properly function. So to prevent that and to ensure efficient government, constitutional ouster clauses in general are brought out. So this is a judgment from Gunawardena versus Patirana, where Justice Vanasundara highlights the reason for implementing these constitutional ouster clauses in general. So he stresses that the government found itself practically hamstrung by injunctions and court orders and not given a free hand to run the public service. So that was one reason, and therefore he said the public service must be made the exclusive domain of the executive without interference from the courts. So that is the justification for having these clauses. So, if there are such justifications for having these clauses, then why do the courts circumvent these clauses or in certain instances disregard these clauses? Firstly, they rely on the principle known as the rule of law, which is another constitutional principle, which is based on the fact that they believe that these ouster clauses, to a certain extent, deny the people's right to access judicial remedies. So, they rely on that in order to circumvent or disregard these ouster clauses. And also, the courts contend that they are actually giving effect to parliamentary intent rather than usurping parliamentary authority by saying that the parliament would have never intended for administrative authorities to act with impunity, because an enacting statute specifies the scope and the limits of an administrative authority's powers. So if there is then a clause that says that these limits cannot be enforced, that would not have been the parliament's intent when they had enacting statutes. So based on those two principles, the courts justify the circumvention of these clauses. So I'll quickly move on to the classification of ouster clauses. Generally, they are based on the source. These ouster clauses found in the Constitution are known as constitutional ouster clauses, and these are again subdivided as ouster clauses that protect legislative action and ouster clauses that protect executive action. So we have four, and those are divided accordingly as I have depicted in the graph. So I will not be going into detail about the first three ouster clauses since in the interest of time. I will be focusing on Article 61A, which is like the recent addition under the 17th Amendment. So this is a comparison between Article 55.5, which existed prior to the 17th Amendment, and Article 61A. So this is the languages of each provision and the common exception. So this is where Article 55 and Article 61A are similar. They are similar in regard to the courts have held that in cases of improper delegation, the court cannot. In the case of improper delegation, the court can review judicial action, and that is shared between these two articles. And also, if there's an infringement or an imminent infringement of fundamental rights, again the courts can intervene disregarding these ouster clauses. So both these articles agree. However, the deviation exists with regard to challenging the decision itself. So, under Article 55, as mentioned in JC versus Sisyphean, an unlawful decision was challenged by the courts. However, under Article 61A, this showed the courts exhibited a reluctance to question the legality of the decision. So, the decision itself is, the courts have been quite reluctant under Article 61A to challenge the decision itself based on grounds such as illegality. So now the reasons for this deviation is of importance here, because the 17th Amendment brought about a lot of changes. So if I may be allowed another minute to sum up my presentation. Thank you. The changes introduced by the 17th Amendment are the reasons as to why there is such a deviation. So first, you get the availability of extrajudicial remedies. So instead of going to court, a person can appeal first to the Public Service Commission under Article 58, and if they do not agree with the decision of the Public Service Commission, they can further appeal to the Administrative Appeals Tribunal. So there are extrajudicial remedies in place instead of applying directly to court. And secondly, as we noticed by the writings of Justice Masuk and so on, that the Sri Lankan fundamental rights jurisdiction has expanded quite rapidly over the past decades. So based on that, if there's a person can make an application to the Supreme Court for an infringement of a fundamental right, rather than going to the Court of Appeal for a writ. So basically, I believe that constitutional ouster clauses, they play a very pivotal role in maintaining this balance between these three organs of government, and it is important to balance the need for efficient government while safeguarding the rights of the people as well. So that is where constitutional ouster clauses or ouster clauses in general play a big role. So in order to facilitate that, it is important to balance those two interests. So with regard to 61A, there has been deviation with regard to challenging the decision itself. So that is, and I believe that that is justified based on the fact that there is now extrajudicial remedies under the 17th Amendment, such as the Administrative Appeals Tribunal and so on. So this deviation of the courts showing reluctance to circumvent or disregard these constitutional ouster clauses is completely justified based on that. And these are the references that I used. Thank you very much.
Thank you. Well, for those of you who thought that we had, after 5 presentations, it would be finished, we have a surprise. We already have a very rich meal with food for thought, but there's an unexpected dessert, and that is the 6th presentation on tax amnesties. The case of sticks and carrots, sticking to food. Now we will have sticks and carrots, we will hear about sticks and carrots, but in the context of tax amnesties. This is a paper prepared by 3 authors. I suspect that only one of the 3 will speak, unless the 3 of you will together present, but it's you who will present. Ms. Disanayake. She is currently following final year studies for her Bachelor of Law degree here at KDU. She is also an ACCA affiliate. I must confess I don't know what an ACCA is, but I hope you all know. The other 2 authors are Ms. Madhushani, is currently following final year studies also for her Bachelor of Laws here at KDU, while simultaneously following final stage of professional qualification in human resource management at the Institute of Personnel Management. And then the third, Ms. Vera Koddy, obtained her business management degree from the Northumbria University in UK and is currently following final year studies again for Bachelor of Laws program here at KDU. She is also following a postgraduate diploma in international relations at the Gunawardena Center for International Studies. You have the floor on behalf of all 3.
Good afternoon. So first of all, it's been my pleasure and privilege to present our first research paper in your research. Good afternoon. It's both my pleasure and privilege to present our first research paper in your presence, the distinguished guests, the panel, and my colleagues here today. And especially in the side of our very own university, our research is on tax amnesties and its impact. So, to introduce what a tax amnesty is, it provides a time-bound window and an opportunity to the taxpayers to pay a defined amount in exchange for forgiveness, the tax liability payable for the past periods, including interest and penalties, will be overlooked by tax amnesty. A tax evader who makes use of an amnesty will not be criminally prosecuted for his past mistakes. And why would you use a tax amnesty? The argument is mostly twofold. There is an economic point of view as well as the tax administrator's point of view. In the economic point of view, the objective of declaring a tax amnesty is to contribute to the development of the country, which is the objective of collecting tax revenue as well, and by increasing money in circulation and capital reserves, by introducing large wealth amassed but not declared or invested in the formal economy of the country into the formal economy, is the tax amnesty's way of contributing to the country's development. And to move on to the tax administrator's point of view, compliance and revenue enhancing tools such as amnesties are strategic measures adopted to bring tax evaders into the tax net voluntarily, thereby enabling tax revenue to reach its potentiality. For this purpose, carrots such as pardon for past evasions, non-implementation of legislative powers to investigate and prosecute are promised to the debtors. Sadly, in the case of Sri Lanka or in other countries where tax amnesties have been declared, it's mostly a political tactic where the twofold arguments are often ignored. And the Sri Lankan experience and the efforts to address non-compliance and lack of compliance, it does not only involve tax amnesties. Prosecuting and imposition of penalties on offenders, specifically those on those who do not submit returns, have been widely used to curb the problem of non-compliance in Sri Lanka. Other measures used to enhance compliance include auditing and investigations, collection of tax at sources, as in the case of withholding tax, and use of information, field surveys, and maintaining tax